Well, good morning, everyone. Thank you all for coming. And for those of you who do not know me, my name is Mark Herring. I am the newly minted Attorney General of Virginia. With me is Cynthia Hudson, Chief Deputy Attorney General, and Stuart Raphael, Solicitor General. In 1 week, a federal judge in Norfolk will hear arguments in the case of Bostick versus Rainey. Timothy Bostick and Tony London live in Norfolk. They've been together as a loving and committed couple for 25 years. Janet Rainey is Virginia's Registrar of Vital Records and the individual charged with enforcing our state constitutional ban on marriage between same-sex couples. The other two plaintiffs, Carol Shaw and Mary Townley, live in the Richmond area. Their relationship of 3 decades was formalized in 2008 in a marriage in the state of California. Together they have a 15-year-old daughter. These two couples want Virginia to recognize their love and commitment. From that recognition, they would derive obvious benefits, such as hospital visitation, basic parental rights, and clear survivor benefits. They would also derive the enormous intangible benefit of societal recognition. I believe the freedom to marry is a fundamental right, and I intend to ensure that Virginia is on the right side of history and on the right side of the law. Today, I have notified the United States District Court for the Eastern District of Virginia of a change in Virginia's position in the case of Bostick versus Rainey. After thorough and independent review, I have concluded that Virginia's ban on marriage between same-sex couples violates the due process and equal protection clauses of the 14th Amendment to the United States Constitution. As Attorney General, I cannot and will not defend a law that violates Virginians' fundamental constitutional rights. And accordingly, in light of next week's scheduled argument, the Commonwealth will instead side with the plaintiffs who have brought this case and side with every other Virginia couple whose right to marry is being denied solely on the basis of their sexual orientation. This decision is based on my analysis of the law and my duty to fulfill the obligations of the Office of Attorney General. There are those who will say that the Attorney General is required to defend every challenge to a state law, even a law that is unconstitutional. They could not be more wrong. There is solid precedent for my actions here today. To defend a law that I have concluded is unconstitutional after a thorough legal review would be a violation of my oath, a misuse of the office, and would be inconsistent with the precedents established by prior Virginia Attorneys General. Former Attorney General Cuccinelli refused to defend the Opportunity Educational Institution last year after determining that it violates the Virginia Constitution. He was right to do so. Former Attorney General Jerry Kilgore joined with 43 other state attorneys general in 2003 to argue that an attorney general is properly carrying out his constitutional duties when he seeks to invalidate a state law that he believes, in his independent judgment, to be unconstitutional. In that brief, Attorney General Kilgore and the other attorneys general said, when an attorney general believes a statute violates the Constitution, he has a paramount obligation to defend the Constitution he is sworn to uphold. The brief also said, while the Attorney General is obligated to represent state officials and agencies to the best of his abilities, he need not, indeed must not, do so at the expense of the people as a whole. To do so would be an abdication of official responsibility. Even conservative jurists such as Robert Bork, John Roberts, Justice Scalia have agreed that this is the appropriate role of an Attorney General. Therefore, Having determined after thorough, rigorous legal analysis that an unconstitutional law is infringing on the rights of Virginia families, I have a duty and the authority to act to protect them and their rights. But my decision today does not mean, and I want to be clear about this, it does not mean that the case will end, nor does it mean that the ban will go undefended or unenforced until the courts can rule on the matter. The State Registrar, Janet Rainey, will continue to enforce the current ban, but neither she nor I will defend its constitutionality. Counsel to the clerk of the court in Norfolk Circuit Court and a national law organization representing the clerk of the Prince William County Circuit Court will remain in the case and continue to argue in favor of the legality of Virginia's ban on marriage rights for same-sex couples. This will ensure all sides of the argument are presented to enable the courts to render a decision. Even as courageous Virginians have advanced the cause of equality, the Commonwealth of Virginia has too often argued on the wrong side of our nation's landmark Supreme Court cases. With Prince Edward County as defendant in the landmark school desegregation case of Brown versus Board of Education in 1954, with the Commonwealth fighting the right for Mildred and Richard Loving to marry, despite their race, in 1967 in the Loving decision. And in 1996, to oppose opening VMI to female cadets. The same legal principles that applied in those cases apply in this case today. As a legislator in 2006, I voted against the right of same-sex couples to marry. Even at that time, I spoke about the need to fight other forms of discrimination against Virginians based on their sexual orientation. But I was wrong to stop short of marriage equality. Like millions of Americans, I've thought hard about the issues involved, including the legal issues. And I have talked with my family, with friends, co-workers, and constituents about the human impact. And since I have spoken publicly about how my views have changed and how I have arrived at a better, more inclusive place. But I want to be clear that my decision today is not based on my policy preference for marriage rights for same-sex couples. It is based on my thorough analysis of the applicable law and the constitutional questions raised by this case. Virginia is in many ways the cradle of democracy. Washington, Jefferson, Madison, Mason, Monroe, and others called our state home. And America's first freedom, religious freedom, was written into law just a few steps and blocks away from where we stand. As Virginians, we have much to be proud of. But too many times in our history, our citizens have had to lead the way on civil rights, while their leaders stood against them. This will not be another instance. It's time for the Commonwealth to be on the right side of history and the right side of the law. Writing for the majority in 2003 in the Lawrence versus Texas case, Justice Kennedy explained for the court that the Constitution's framers, quote, "New times can blind us to certain truths and later generations can see that laws once thought necessary and proper, in fact, serve only to oppress." Well, that is certainly the case here. And I will fight to end this oppressive ban and to guarantee the constitutional freedom for loving couples to marry in Virginia. That is because of the oath I swore when I took office, and that is my paramount obligation. be happy to take your questions. Marcus.
Yeah, the Republicans this morning already have hinted that they're not going to let this go down without a fight. There's some talk of impeachment proceedings. How would you address this?
Well, first of all, I appreciate their political commentary, but I am doing the duty I was sworn to do. An Attorney General has a duty to support those laws that are constitutional and validly adopted. And an Attorney General has just as strong an obligation and duty not to defend laws that he has concluded are unconstitutional after a careful and thorough review. And it's that simple. I took an oath 2 weeks ago, just less than 2 weeks ago, to uphold and support the Virginia Constitution and support the United States Constitution. And the United States Constitution is the law of the land. So a state law and a state constitution cannot violate the United States Constitution, and I swore a duty to uphold both, and the Supreme Court is clear. The United States Constitution is the law of the land, supreme law of the land. Julian.
With respect to the timing of this announcement, is it all hinged on the upcoming hearing, or are there other factors that weigh into this announcement today?
It's really the procedural posture of the case. Certainly, I think most of us were aware of the case. I was aware of the case last year. When it became clear that I had won the election, I knew that we were going to have to work hard and quickly on this issue right away, because the case has been fully briefed on cross motions for summary judgment and is scheduled for oral argument on January 30th. So that really explains the timing of it. Yes?
Where will the resources come from for the counties that continue to defend the law?
Well, first of all, the change in position is not going to result in the appointment of any special counsel. I will continue to represent the registrar and present the Commonwealth's legal position. It's just that the legal position is now different than it was previously. The clerk in Norfolk has had counsel appointed by the Division of Risk Management, and I think an outside national legal group is providing counsel for the clerk in Prince William.
When you voted for this law, why did you think it was constitutional at that time? Did you believe it was constitutional? Did you do that analysis?
You know, as I said, I did vote for the law in 2006, but my feelings about the policy as well as the law have changed since then. And there is a lot of new legal guidance that addresses that. And let me talk about sort of two pieces of it. One piece are recent cases dealing with discrimination on the basis of sexual orientation. The other strand is a long line of cases supporting the fundamental right to marry. Most recently, last year, the Supreme Court addressed two cases. In the Windsor case, it struck down Section 3 of the Defense of Marriage Act. And in that case, writing for the court, Justice Kennedy made it clear that the Due Process Clause is violated by treating same-sex married couples as second-class citizens. I think it's interesting and notable that Justice Scalia, in his defense, said that the majority's decision in the case could and would be used as justification for striking down states' gay marriage bans. And I think that analysis is right. The other case was effectively nullifying California's marriage ban for same-sex couples. And that, too, was one that had been voted on by the people and part of the state constitution. So those are two very recent cases just last year dealing with discrimination on the basis of sexual orientation. Then there is the long line of cases protecting the right of marriage going back, you know, many, many years, including the Loving decision in 1967. Yes?
One of the issues the Propley case was outside counsel defending the law. It sounds like you're trying to avoid that situation, but I'm still kind of confused on that. You said outside counsel should be representing one of the counties that will do that?
The Division of Risk Management has policies that cover defense costs for officials who are sued in their official capacities. And counsel was previously appointed when the case came forward, and they are representing the clerk in Norfolk. And the reason special counsel, one of the reasons special counsel is not needed to be appointed here is that there are parties who will continue to argue in favor of the legality of Virginia's ban, and they're able counsel and will continue to argue that, as well as the national law group that is representing the Prince William County clerk.
But isn't that still an outside, non-governmental group fighting this case? I'm sorry if I'm mistaken.
Well, it's the clerk who's doing it, and I don't know what the financial arrangements are between the clerk and Prince William, but I suspect, although I don't know, that they're doing it with their own resources on behalf of the clerk. Yes.
Mr. Attorney General, will you yourself be appearing in court in Norfolk next Friday, or will it be someone else?
I haven't decided whether I personally will be there. I'm confident that the Solicitor General, Stuart Raphael, will be there and will argue on behalf of the Attorney General's office and the Commonwealth.
General, given the new position from the Attorney General's office, does anything change for Virginians? Does the law change in any way, or do policies change in any way?
This action today is not going to change the law. That's going to continue to be enforced as it has been. But what's different is the chief legal officer for the state, the Attorney General, who is charged with presenting the state's legal position, will be coming forward with strong and persuasive legal arguments as to why this law is unconstitutional. And I think that's important and significant, not just because of the legal history involving Virginia in some of these landmark cases previously, but it's also important for the parties to the case, for those Virginians who are currently being denied their right to marry, and frankly for all Virginians to know that their Attorney General is going to be on the side of the law and of the people.
The head of the Republican Party has called on you to resign from office, saying you don't want to do the job of Attorney General. What's your reaction to that?
I am doing the job of the Attorney General. And I am called upon as Attorney General to present the state's legal position. I am required to do a thorough and independent analysis of the law. I've asked Stuart Raphael as Solicitor General to head that team up. We have done that thorough and independent analysis and concluded the law is unconstitutional, and it would be contrary to my duties to continue to defend a law that I concluded was unconstitutional and depriving the rights of Virginians. Yes?
You want the legal aspects of it, but are you a native Virginian?
I was born in Johnson City, Tennessee, but I grew up here in Loudoun County in Virginia.
So your views have changed and evolved on this. I'm just wondering what you think of the Attorney General from the southern state taking this position. It seems like it resonates sort of beyond California's other state.
I think I'll let others speculate about the significance of the action that we're taking and that it's happening in Virginia. My focus as Attorney General is doing the job I was elected to do and making sure that I was faithfully analyzing the law and presenting the case for the Commonwealth and for the people. My focus is on Virginians.
How does Virginia's action today, how does it affect the movement of this country? I mean, might this case, based on its arrival at Supreme Court?
It may well be. It's hard to predict. Again, my primary focus is on doing the job I was elected to do right here in Virginia. Ultimately, this issue is going to have to be resolved by the courts, ultimately by, I think, the United States Supreme Court. Whether this is going to be the case, whether it's another one in another part of the country, maybe it's several cases, I don't know. We'll have to tell. But right now, my focus is on Virginians and their constitutional rights. Yes.
What's your opinion of the legislature's ability to hire its own counsel? And to go a step further, what if just the House wants to hire its own counsel? Would they have legal standing to do so?
Virginia has one attorney general, and I think it's going to stay that way.
And then can I ask one other question?
Sure.
Have you worked with the counsel for the clerks? Have you all worked together on this case? And if so, does that then pollute your case now that you're switching sides? Have you seen the playbook?
What I've done is communicate our position with all of the other counsel involved, and that's not unusual. That's frankly customary in any court case where lawyers will let the other lawyers in the case know this is our position and this is what we're going to be filing.
So you don't, just to be clear, you don't feel like this is going to cause some sort of appealable conflict of interest issue?
No.
I don't know the legal terms.
No. Yes.
Do you have the governor's support?
I had mentioned it to the governor as we were getting close to, the other day. Our team has briefed the governor's team fully on what we were doing, and he's in agreement with the steps we're taking.
Mayor?
Yes.
So the last few years, your position has sort of evolved, and during that time, you've had a conversation with your family. What sort of things have you said to your children and vice versa?
Well, let me say, really from the beginning, back in 2006 after that vote, I saw how that vote hurt a lot of people. And it was painful for a lot of people. And I continued to think about it, just like Americans everywhere have continued to think about this issue. I've talked to my constituents about it as a state senator, talked to coworkers and friends and family. And really what they were doing was pressing me a little bit to continue to question whether the vote I had taken back in 2006 was the right one. And I have just come to the conclusion that I wouldn't want the state telling my son or my daughter who they can and cannot marry.
Do one more, guys? Or hearing none, clerk will close the roll. All right, thank you.
Thank you very much. If you have any other questions or inquiries, I'd ask that you direct them to Michael Kelly, Communications Director, and thank you all for coming.